morning. Thank you for joining us. So we're going to spend some time today talking about obtaining a green card based on employment. In particular, we'll focus mostly on obtaining a green card through the PERM labor certification process. A few things before we get started. So Scott Legal is a full-service immigration firm, focuses on a number of different types of visas, including green cards through employer sponsorship. We will continue our webinar series, doing at least 2 webinars a month on various immigration topics. At the end of this webinar, you'll get a few things. One is a PowerPoint that discusses some of the topics we'll cover today. Another is a comprehensive guide going over the PERM process, and also a link to where you can sign up for additional webinars. So for our panelists today, we're very lucky to have Michaela Vrazdova, who's a senior associate at Scott Legal and has significant experience working on various employment-based green cards. My name is Kelly LeGrand Wiener, and I'm the managing attorney at Scott Legal, and also have significant experience with employment-based green cards, particularly the PERM process. So without, if you have questions, please send them to the chat box. And also this webinar is being recorded and will be made available on demand. So without further delay, we'll get started with some questions that we often see in relation to employment-based green cards. So Michaela, could you describe just what are the employment-based green card categories?
Yeah, and good morning, everyone. So there are basically 5 employment-based green card categories. So the first one is called an EB-1A green card. So this green card is for individuals who have an extraordinary ability in the field of sciences, arts, education, business, or athletics. And basically, to qualify for this green card, you would have to show that you are one of the small percentage of people in your field that have arisen to the very top of your field. And you would have to show that you sustain a national or international acclaim, and your achievements have been recognized in your field of expertise. So basically, the EB-1A green card is reserved for people who are kind of like well-known and experts in their field and are kind of like in the very top of their field. And we'll discuss this a bit more detail later. Then the second green card category is called EB2, and one subcategory of this green card is called a national interest waiver. And again, we'll discuss this in a little bit more detail, but a big advantage of the national interest waiver is that you can self-petition yourself for this green card. And another advantage is that you don't have to go through this complicated, or the company doesn't have to go through this complicated labor certification process and through the PERM process. Then another kind of like subcategory of the EB2 is the EB2 green card based on the PERM process. And to kind of qualify for this green card, you would need to find a company, and this company would basically need to sponsor you for this green card. And to qualify for this green card, you would have to have at least an advanced degree, and the job in the US would have to require an advanced degree. An advanced degree is defined as a master's or a bachelor degree and 5 years of experience. The third category of employment-based green card is called an EB3 green card. And again, for this category of green card, you would have to have a US company sponsoring you for the green card. You cannot self-petition yourself. And yeah, so we'll discuss the EB2, EB3 green card categories in a bit more detail later in this presentation. The fourth category is called an EB4 green card, and this green card is reserved for so-called special immigrants. So there are some types of immigrants defined in regulations that would qualify for this green card. For example, religious workers, certain broadcasters, some just kind of like very special categories of people. And the last green card category is called an EB-5 green card. And for this green card, you would have to invest money in the US. So you would have to invest at least 1.8 million or $900,000 depending whether or not you are investing the money in a targeted employment area. Then the business you are investing the money into would have to create 10 full-time jobs. And for if you're interested in this type of green card, we have special webinar kind of going over the requirements in a bit more detail.
Perfect, thank you. And so, Michaela, could you talk a little bit more about just, what is the EB-1 Extraordinary Ability Green Card and what those requirements are?
Yeah, so as I mentioned, so for this green card, you would have to show that you are one of the small percentage of people in your specific field who have risen to the very top of your field. And so how can you show that you kind of meet this standard? So you would either have to show that you have won some sort of national or internationally recognized award, such as Nobel Prize or some kind of major award like that. And if you don't have such an award, then you would have to meet 3 of 10 criteria. I will not go over them in much detail here, but some of the criteria are, for example, evidence that you are a member of association in your field that demands outstanding achievement of the members. Another type of evidence you would have to submit is, for example, evidence that there is published material about you and your achievement. The criteria will be kind of listed in the guide we'll send you, but you would have to show that you meet at least, you don't have to meet all 10, you would have to show that you meet at least 3 out of the 10. And then how USCIS adjudicates these petitions is that they use kind of like a 2-step analysis. So they first kind of look at the kind of evidence that you submitted. They look whether you whether you have kind of like the one internationally recognized award or whether you meet 3 out of the 10 criteria. So that's the first step. So if you submit evidence kind of meeting that, then they move to the second step of the analysis. And in the second step of the analysis, they kind of look at the quality of the evidence. So for example, if you submit evidence that there are published articles about you, they look at, like what are the kind of the publications, like where are the articles submitted, like is it like like famous magazines, like famous publications in your field, or is it kind of like a smaller publication in your home country? So they would kind of like assess all the evidence, like the quality of the evidence, and then they would make the final determination whether or not you meet the EB-1A standard. And as I mentioned, huge advantage of this of this green card category is that you can self-petition yourself. So you don't need to have like a job offer from any US company. As long as you are able to show that you meet the standard, you can just file a petition on your behalf and self-petition yourself. And if it's approved, you can just come to the US, set up a company in the US, or kind of like keep operating the company you have in the US. So that's a big advantage of this green card category.
Perfect, thank you. And could you describe just really briefly the EB-2? I know you mentioned there's a national interest waiver aspect or option for the EB-2 that's kind of separate from the PERM.
Yeah. So for the national interest waiver, so you would have to show that you either have an advanced degree, so this means at least a master's degree or a bachelor's degree plus 5 years of progressive work experience. Or if you don't have a degree, then you would need to show that you have exceptional ability. You would need to meet at least 3 out of 7 criteria that are kind of defined in the regulations, and you can kind of review these criteria in the materials we'll send to you. So just one important thing to keep in mind is that, if you have an advanced degree, you can qualify based on the degree, but even if you don't, there is an option to qualify through the exceptional ability kind of standard. And then you would have to show that you are that the proposed endeavor you are kind of like planning to do in the US has both a substantial merit and national importance. You would have to show that you are well positioned to advance the proposed endeavor. And then you would have to show that on balance, it would be beneficial to the US to waive the requirement of the job offer and of the labor certification.
Perfect, thank you. So I think we'll switch gears now to start talking about the PERM, and Michaela will kind of take over some of the questions.
Yeah, Kelly. So can you go over what is the labor certification process?
Sure. So the labor certification process is kind of the normal process, through which employers in the United States sponsor, foreign nationals for green cards for kind of permanent employment in the U.S. And then the way that this works is the categories that are relevant for the labor certification are the EB2 and the EB3 categories. So even though the EB2, as you just mentioned, can be used in this national interest waiver category, that national interest waiver is actually a waiver of the normal labor certification process that a person should go through to get a green card in the EB2 category. So the way that the EB2 or an EB3 work, it's really a 3-step process. And within that first process, that's the labor certification. And that process itself has many steps. So within that process, the sponsoring employer, has to first, create a job description for the position that the person will hold. Sometimes the person is already working for that company. Very often they are on a, visa like an H-1B or an L-1 or something like that. Then they need to file for a prevailing wage with the Department of Labor. So this is where they will provide the job description, the job requirements, the location of the job, which is very important. And then the Department of Labor will issue a prevailing wage based on the category of the job and, the statistics of wages in that particular area. Once the prevailing wage comes back, then the company can go through what we call the recruitment process. And this is what many people have heard of, where you have to actually test the labor market. So this is where the company actually has to place advertisements. Depending on what type of job it is, it's either 3 mandated types of advertisements or 6 mandated types of advertisements. And that process, the actual recruitment process by regulation has to be at least 60 days, 30 days where there's kind of active ads being placed and they're, reviewing resumes, and then kind of 30 days where if anyone's applying, they still have to, review any resumes that come in, but the ads are usually no longer active by that point, or maybe only one ad is active. If during that process, when they're testing the labor market, they find any willing, qualified, and available U.S. workers for the position, then that whole PERM process has to stop, because they've tested the labor market and they've found a U.S. worker who could, hold the position. If during the process they do not find any willing, qualified, and available U.S. workers who meet the requirements for the job, then they can go ahead and file the labor certification with the Department of Labor. It is in what we call an attestation-based system. So that means that the employer is essentially submitting a form that says, yes, we did everything that that is required. We placed all the ads. The employer also must create what we call an audit file. So that's the actual proof, those documents. Those aren't submitted up front, but if the case is audited, then the employer has to go ahead, usually within 30 days, submit that that audit file, that proof that they actually did, place the advertisements. They have to submit usually resumes of the people who applied, their commentary on why those people were not qualified. If the requirements for the job are outside what the Department of Labor considers normal, they may also have to submit what we call business necessity documentation. And so all of this is submitted to the Department of Labor. So we're not really dealing yet with U.S. Citizenship and Immigration Services, which is what people are generally familiar with for immigration. We're all dealing with the Department of Labor right now. If the Department of Labor certifies the labor certification, then that allows the employer and employee to move on to the next step of the PERM, that second step. And that's where we file Form I-140. Form I-140 is, where the employer needs to prove that they have the ability to pay the prevailing wage, and they need to show they had that ability from the time they filed the labor certification, and they have that ability up through the time the person gets the green card. And then the person, the actual applicant, has to show that they meet the requirements for the job. So let's say that during the PERM process, the job description said that this job requires a bachelor's degree plus 5 years of post-baccalaureate progressive experience. At the I-140 stage, the applicant actually has to submit the proof of that bachelor's degree, so the transcripts, the diploma, possibly an educational equivalency evaluation if the degree is from another country outside the US. And then they also have to submit employer letters, that provide specific detail about the job duties, the dates of employment, and what the actual, what the person actually did for the company. So that's, important for the I-140. Then if the visa category is current, so let's say the person's in the United States and there's no backlog in the EB2 or EB3 categories for them, then they can go ahead and file the I-485. That's the green card application. The I-140 and the I-485 can be concurrently filed, so those can be filed together. Sometimes employers prefer to file the I-140 first because you can apply for premium processing. You can get an answer in 15 calendar days for the EB2 or EB3. And then if that's approved, you can go ahead with the green card application. There's also some, some people where they don't have that option. So for example, Chinese nationals and Indian nationals, or people born in India or China, their categories in EB2 and EB3 are generally backlogged. So that means that even when the I-140 is approved, they're not able to file that green card application yet. They have to wait until their date is current, and then they're allowed to go ahead and file the green card application. So that's kind of the basic labor certification process from end to end.
And Kelly, how long does this entire process take approximately?
Right. So I'd say that the, an important thing to know is just that the timing varies. Over the years, there have been times where it might take 1.5 to 2 years. Up to now, it might take closer to 3 to 4 years. And the reason is that you're dealing with lots of different agencies. So when you're filing the prevailing wage, that's one agency within the Department of Labor. And right now, those are taking somewhere between, 8 to 10 months to be issued. So that's, 8 to 10 months where you're essentially just waiting. So then after you get that, or sometimes there's circumstances where you can file a little bit earlier, then by regulation the recruitment's going to take at least 2 months. So that's already gotten you to 10 months, 12 months. Then when you actually submit the labor certification right now, I think those processing times are somewhere between 6 to 8 months. So that puts us, so if those processing times right now are very long. At other times, they've been much shorter. Sometimes, it would take 3 months to get a labor certification or 3 or 4 months to get a prevailing wage. So the timeline can vary significantly. But I think the important takeaway is that it is a multi-year process. Even when things are going very quickly, you're looking at 1 to 2 years, just because even once you get past the Department of Labor, the only part of the process that can really be sped up is the I-140 part of the process. So once you get there, you can file for premium processing. You can get an answer in 15 calendar days. But then if you're filing for your green card, that cannot be expedited. And many service centers and many field offices are taking a year or even upwards of a year to process the actual green card application. So I think, it's important to always discuss when you're starting the process, with an attorney, you always want to plan for if the person's in the United States, what is their underlying status, make a plan for kind of, will they need to do a renewal? Will there be any issues with that? We'll talk about intent issues a little bit later. So like just very important to kind of keep in mind, okay, this is not going to happen within a matter of months. It's going to be a matter of years. And how do I plan with my employer to make sure that if my goal is to stay in the US, that I'm planning for my visa renewals, because during the PERM process and when the I-140 is filed, that doesn't give you any ability to stay in the US. You need an underlying visa status if you want to stay in the US during that time. So I'd say right now we're seeing it take closer to the 3 to 4 year mark. But that's obviously always going to be shifting because the Department of Labor timelines and USCIS timelines are always changing.
And Kelly, can family members of the kind of like the main applicant of the employee also get green cards?
They can. So when you finally get to that green card stage of the process, you can sponsor your spouse and any children that you have under 21. So that's another good thing to keep in mind, is just wanting to work with your employer, file early, particularly if you have children. If you're concerned about your children, aging out, like during the process, you want to get that started faster.
And what are kind of like the fees that need to be paid in the green card process, and who can pay the fees? Can the employee pay these fees?
So for most of the fees, the answer is no. During this process, there's generally going to be legal fees. The company is going to have to hire an attorney to get through the PERM process. There's not kind of Department of Labor fees associated with the prevailing wage or filing the labor certification, but there are fees you have to pay to place advertisements. So for example, you're required to place Sunday newspaper advertisements, that's usually a fee. There's other, on the mandated list of advertisement options, most of them have some fee attached. There's a few $1,000s there. Then once you get to the I-140, there's filing fees to the government. For the I-485, there's filing fees to the government, and there's legal fees. For the vast majority of fees, the employee applicant cannot pay. So specifically for the PERM, very strict, very clear, the applicant cannot pay these fees. And there can't be an arrangement either that the employee is actually paying and then the employer just sends the fees to the lawyer. The employer has to be the one that's engaged for the process and paying for the process. There are certain things the employee can pay for. So for example, premium processing for the I-140, when you get to the green card stage of the process, the fees for the dependents, all of those can be paid by the employee, but it's, for the other pieces, no, the employee should not be paying.
And Kelly, what things should an applicant kind of like keep in mind when moving from a visa to a green card?
Sure. So I think that, things to keep in mind, so one is kind of timing and your underlying visa status. So consider how much time is left on your underlying visa. Some visas are harder to extend once you have an immigrant petition filed. So for example, if you're on a TN visa, those can be granted initially for maybe, for 3 years. If you're coming to the end of your TN, and you're at a certain stage of the green card process, you may want to renew before that I-140 is filed, because once the I-140 is filed, there's this indication you have immigrant intent, and the TN requires that you do not have immigrant intent. So you want to just kind of always think about that. Always also think about, do you want to adjust status in the US, or do you want to get a green card through consular processing? If you adjust status in the US, that's usually appropriate for people that are already living in the US, that their main home is there at this particular time. They want to work there, they want to live there. And a key part of that also is that once you file your adjustment of status, for many people, they cannot travel once that's filed until they get a travel authorization card. If they did travel, they would abandon their green card application. So if you're doing that, if you're doing an adjustment of status, you want to kind of make sure that you're timing it appropriately, speaking with your lawyer to make sure that, at the time that it's filed, you're okay with not traveling for a while. If you're on an H-1B or an L and you meet specific requirements, you may have a benefit of not having to wait for that travel authorization. But let's say you're on a TN and they file your adjustment of status, you now cannot travel outside the United States until you get your travel authorization. So you want to just always be planning for that. If you're someone who your work just requires you to travel a lot, or your family requires you to travel a lot, consular processing is probably going to be a better option for you to get the green card if that's your circumstance. Another consideration you want to take into account, which I mentioned previously, is just, the age of your children. Do you want your children to have that green card? If so, try to time it appropriately so that your kids are not aging out. Once they're 21, once they're married, they're not able to be dependents on your green card application.
And Kelly, what visas have and are kind of like a non-immigrant visas, and what visas have dual intent, and how is this important in the green card process?
Sure. So for non-immigrant visas, some of them have dual intent. And so what that means that they're basically allowed to have an immigrant green card petition pending, and it doesn't have any bearing on whether they can renew. So the H-1B and the L are real kind of solidly dual intent visas, where it's just heavily acknowledged in the regulations that it's okay for people on these visas to have the intent to get a green card. And this is shown in many ways. So even just the fact that H-1B and L have the ability to continue to travel even after their adjustment of status applications are pending. So they get these kind of extra benefits. There's kind of these visas that sometimes are treated as almost quasi dual intent. So like the E and the O, where there's not a very high standard for having to prove, a residence abroad. There's some basis for arguing that you can even extend from within the United States, even if with an adjustment of status pending, kind of an outlier situation, but there is a basis to argue this. And then there's visas, like the F student visa or the TN visa, where they have a very, very high standard. These are not dual intent visas. This is a visa where if you have the intent to immigrate, you are not eligible for this visa. So if let's say you were applying for a TN and they said, well, what's your plan? And you said, well, I'm applying for a green card with my employer and I want to live in the US permanently. Very unlikely that application will go through, because an important, part of qualifying for the TN is that you do have that intent to depart the United States. You can make arguments that, intent is assessed at each entry. So you can, as a TN visa holder, even if perhaps in the future you maybe want a green card, that doesn't prevent you from getting a TN, because at that particular entry, when you're getting your TN, you're not really sure what your future plans are. But at the point when your plans start to solidify, that's when you want to be working with an immigration attorney. And that's when kind of renewing, a visa that has a high standard of non-immigrant intent is going to be much more difficult to do.
And Kelly, how should an applicant prepare for the green card interview? And is there usually like an interview when you file an adjustment of status application, or are there any cases where these interviews are being waived? And is there an interview when you file at a consulate?
Sure. So I'd say that, the employment-based interviews, if you're doing an adjustment of status, they can be waived. They used to be kind of, before the prior administration, they were kind of very often waived. Then, during those years, 2016, it became much more common for them to actually have interviews. And now it's kind of like they can be waived, but also there can be an interview. If you're going to the consulate, there will be an interview. When you are going to your green card interview, whether it's with USCIS in the United States or at the consulate, you always want to review your immigrant visa petition. You want to review your green card petition. You want to be aware of any issues that are on those petitions. So if you ever had any history of unauthorized work, if you ever had any history of criminal issues, you want to kind of have worked with an attorney to address any admissibility issues and kind of be prepared to argue about or to explain those things with the officer. If you're if you don't have any of those red flags, you want to just be familiar with what is the basis for your immigrant visa petition approval. So they may ask you questions about your employer, about your job, to make sure that it aligns with what's in the immigrant visa petition. They may ask you questions, biographical information, work history, education history. So you want to be prepared to address all those things. For your spouse and your children, you want to have the proper documentation showing these are bona fide relationships, that you have the marriage and birth certificate. You want to kind of organize and print and bring documents that you'll need with you to the interview. You should bring original documents, but also copies of those original documents. Usually you'll get a very detailed list of what they want you to bring. You'll have to bring a medical exam. So if you're in the United States, you do it on what we call Form I-693. You go to a physician and they do a medical exam, and you bring a sealed medical exam with you, or perhaps you've mailed it ahead of time. When you go, you want to get that updated proof of your employment. So if you're currently working for that employer, you can bring your pay stubs. If you're not, you would still bring a letter that, indicates their intent to hire you in the same position that was outlined in the PERM. You want to bring proof of your immigration history. So you need to have maintained your status, during your entire immigration history. And you also want to meet with your attorney and do a practice interview. I think inherently these situations can be nerve-wracking. And so it's, I think, always good to just prepare a bit more to make sure that you, feel comfortable answering these questions.
And Kelly, you mentioned that the entire process takes like 3 to 4 years. So can applicants like change employers during this process? Is that possible?
Sure. So at various times, the answer is yes. I mean, at any time, you can change employers. The question is just, does it preserve any benefit of your green card process? So like, let's say that you are with a company, currently they're testing the labor market for you, and you want to move to a new employer. So you can move to a new employer if your visa status allows. Like, let's say you're on an H-1B and you only have 3 years in, and, they want you on a port to a new H-1B employer, you can certainly do that, but you really don't retain any benefit from the green card application. So if you want to retain a benefit from the green card application, then what happens is you can do something called porting. And porting is what allows you to change employers, but only after your I-485 has been pending for at least 180 days. So when we think about the PERM process as 3 steps, the labor certification step, then the I-140 step, then the I-485 green card, you have to already be 6 months into that green card step for porting to be allowed. So your I-140 has to be kind of approved, so at that point, once you have that or approvable, so once you have that, your I-485 has been pending for 180 days, at that point, the new employer gets this benefit of not having to complete a new PERM for you or a new I-140. However, the new employment must be in the same or a similar occupational classification as the job that was offered to you in the previous I-140. So in your old job, you need to be switching to same or similar occupational classification, and you would file what we call an I-485 Supplement J with USCIS, and you would have to submit proof that this is, a same or similar job. And so, you can do that lots of different ways, similar wages, similar job title, similar job duty, an evaluation of kind of the Bureau of Labor Statistics, if they have, job descriptions on there, anything that's helpful, you can kind of submit, so that's the point at which you can change employers and still retain kind of the benefits of having this green card application pending.
And what about once the employees already get the green card? Can they change employers after, or is there like a specific period of time they have to keep working for the employer that sponsored them?
So there's no specific time that you have to keep working for the employer that sponsored you. However, when you go to your interview, both you and your employer are essentially putting forth to the government that you have a good faith, belief that you will be working at this job permanently. So I think that in circumstances where perhaps, let's say you get your green card and then your employer fires you a week later, for you as the applicant, that's not an issue. Like, that's something that they did. However, if you, as the employee, leave a week later, that's something that could eventually come up, for example, at your naturalization interview, where they would say, well, were you making any misrepresentations? Were you actually planning to work there? So once you have your green card, you really can work anywhere. But usually, because you've made this good faith, kind of attestation that you plan to work permanently at this job, it's usually something where you want to be working there for at least a few months, before you leave. And if you leave sooner or you leave within that few months, there should kind of be an explanation, right? So let's say you're working there and then, your spouse gets transferred to another state and you have to leave. There may be lots of very reasonable reasons, why you have to leave, and you can do that. But just something to keep in mind, particularly if you're interested in naturalizing and becoming a U.S. citizen. You don't want to do anything that would cast doubt on kind of any of the attestations you made during your green card process. Perfect. So I think those are, all the questions that we had. Thank you, Michaela, for joining us today. And I hope this was useful for everyone. And I hope everyone has a wonderful day.
Thank you.